kind of interesting because we already have a patchwork of qualification. Different states have different qualification requirements for anybody to get on a ballot in the state, and those differ from state to state. And so we already have something like a patchwork, but the Supreme Court saw Section 3 as kind of different in kind than those other requirements, because if a state were to determine that somebody had engaged in an insurrection, that would mean that the person were categorically denied access to the ballot. And, there are kind of questions along the way, like, what does insurrection mean? What does it mean to engage in an insurrection? And a number of other questions about how Section 3 operates. So the Supreme Court said, well, the Colorado Supreme Court doesn't have the authority to do this. And the Supreme Court then struck the Colorado Supreme Court's decision. And what that means is that Trump can appear on every state ballot where he otherwise qualifies, which is to say every other state in the union, and any individual state can disqualify him from the ballot. Now, I just want to stop there and say the Supreme Court took up this case at lightning speed. The Colorado Supreme Court issued its decision in late 2023. The Supreme Court had briefing within a couple of months and then rendered a decision within about a month after it heard arguments in the case. This really was extraordinarily quick for such a monumental decision. This is important because it affects the 2024 election. What it meant is that a state like Colorado or Illinois or Maine or any other state that might think that Trump engaged in an insurrection and therefore was disqualified under their own state election laws because of the Elections Clause, Section 3 of the 14th Amendment, that they were not qualified to disqualify Trump from the ballot, which means then that Trump appears on the ballot in those states and therefore can have a significant effect on the outcome of the Republican primary and also the general election in 2024. But the five justices on the Supreme Court went a step further. What they said is not only can states not enforce Section 3, but only Congress can enforce Section 3. In rendering that decision, the court looked at yet a different section of the 14th Amendment, Section 5, which authorizes Congress to enforce the substantive provisions of the 14th Amendment. But Section 5 doesn't say only Congress can enforce the substantive provisions. It just says that Congress can enforce the substantive provisions. And Congress has done this with different civil rights laws over time, enforcing Section 1 of the 14th Amendment, which we mentioned a few minutes ago. But what the court said here is that only Congress can enforce Section 3. Now, the court knew full well at that point that Congress was not going to enforce Section 3, given the politics in Congress. There just weren't the votes to enforce Section 3 against former President Trump. So by saying that only Congress can enforce Section 3, the court was saying that nobody is going to enforce Section 3. Now, that was an extraordinary ruling because, as a matter of fact, it meant that nobody would enforce Section 3, but it was extraordinary for another reason. What it did is take out of the hands of federal courts the power to enforce Section 3 through lawsuits in the federal courts, which would be another way to enforce Section 3. The Supreme Court said, nope, that's not going to happen. Federal courts cannot enforce Section 3 without congressional legislation, and only Congress can enforce Section 3. Again, the opinion had a dramatic impact on the 2024 election. It could potentially have an impact well beyond the 2024 election, because now the Supreme Court has said only Congress can enforce Section 3. So any future insurrectionists, for example, will only be disqualified if Congress enacts legislation that enforces Section 3. Okay, I'm going to pause here just for a second before I talk about the second Trump case this term that also aggrandized presidential authority. Just see if there are any questions or comments.
I do have a couple of questions here. If you're planning to address any of these later, you can punt on them for a minute, but they're They're both good questions. Why does SCOTUS feel it necessary to grant immunity to the president, or former president in this case,
Great
when no
question.
other president has needed it?
Terrific question. I'm going to talk about the immunity case here in just a second, and I'll tell you how the Supreme Court came to that decision, and you can use your own judgment about whether that's a right decision or not.
And then the second question is, can you comment on Snyder versus US regarding the anti-corruption laws that bar officers from taking gifts for past political favors? The person asking the question is saying that they've heard that Ed Burke and Madigan may be using this decision in their own legal troubles.
Yeah, interesting. Okay, so the Supreme Court, and I'm going to talk generally here, about the idea of regulating public corruption. The Supreme Court, in a series of decisions, including Snyder, has really curbed prosecutors' ability to prosecute public officials for corruption in a lot of different ways. The Snyder case falls in this line, and what it means is that it's harder and harder to prosecute public officials for corruption. And if the case or any of these cases in this line is being used by public officials, and I'll confess I haven't followed, for example, the Burke case, and their particular defenses very closely. But but yeah, that's what we're seeing at the Supreme Court, that it is becoming harder to enforce public corruption against public officials in this case and some other cases over the past couple of terms.
Thanks. I have if you're finished with that question, I do have one more that popped up here. Are the SCOTUS justices subject to Section 3? I assume that they mean of the 14th Amendment.
Yes. So it's a good question. And the answer is we don't entirely know. And I'm going to explain why. Section 3 has a lot of vague language in it. I'd mentioned a couple of things that are unanswered in Section 3. For example, who gets to enforce Section 3? Section 3 itself doesn't say. And when the Supreme Court said that only Congress can enforce Section 3, that's a substantial limitation on the enforcement of Section 3. A couple of other things that Section 3 doesn't answer. What is an insurrection? How do we define it? What does it mean to engage in an insurrection? Section 3 also doesn't tell us with particularity which offices are covered by Section 3 and which officers are covered by Section 3. There are a couple of other sort of nits in Section 3 that appear to be unanswered. And I'm saying that hesitantly because we just don't have definitive answers on whether they're even unanswered. But there were some arguments in the Colorado case involving other portions of Section 3. For example, what does it mean to take an oath to support the Constitution? That we don't have definitive answers to. And so I hesitate to say whether Section 3 would apply to Supreme Court justices. I will tell you that if you pull out Section 3 in your pocket Constitution and you take a look at it, my guess is that you would conclude, just as I do, that it pretty plainly would apply to Supreme Court justices. But again, it's not entirely clear from some of the unanswered questions in Section 3. Now, ironically, if the case were ever to get to the Supreme Court, it's the Supreme Court that would get to decide the case. And your guess is probably the same as mine, that the Supreme Court is unlikely to determine that Section 3 applies to it, or find some other escape hatch for justices on the Supreme Court. But I hate to do this, but I'm going to kind of punt on the question, just given the what may be indeterminacies in Section 3. And I'll refer you to Section 3 itself, the language, and you can use your own judgment.
Thanks, Steve. That's all the questions for now.
Okay, that's terrific. I really appreciate the questions. And if you have other questions as we go, please feel free to pipe in. I think what I'll do is just take pauses at the end of, here and there just to kind of let us catch up with ideas and questions. So the other case that I want to talk to you about is goes to the second question that we just heard, and that is presidential immunity. So this requires a little bit of a backstory, some or all of which you may already know. So please pardon me if you already know this. You know that Special Counsel Jack Smith brought an indictment against Trump for insurrection on January 6th. Now, here I want to talk specifically about what Jack Smith had alleged then President Trump did to support the insurrection on January 6th so that we understand the extent of the immunity that former President Trump may now enjoy for having participated in that insurrection. So there were a couple of things that the special counsel alleged that former President Trump did on January 6th. And here, I think what I'm going to do is start kind of roughly chronologically, although even as I'm saying that, I'm not sure that's right. But, what happened on January 6th, we all saw on television, but there was a whole series of events that led up to January 6th that's important to understand in order to get a sense of the immunity that former President Trump may now enjoy. And so, for example, when President Trump was in office, after the election returns came in, President Trump waged a campaign to persuade state legislators to overturn the popular vote elections in their states, in states like Michigan or Pennsylvania and Georgia. And what he did was argue that state legislators have the authority under what we call the independent state legislature theory. And I can riff on that if you're interested, but I'm just going to kind of gloss over it for now. The idea here is that state legislatures would have the plenary power to allocate their electoral votes in a presidential election, irrespective of the popular vote in their state. And what President Trump was saying after the election returns came in is that state legislatures ought to overturn the popular vote in their state and unilaterally, using their plenary power to allocate their electoral votes, unilaterally reallocate their electoral votes, not to Biden, but rather to Trump, again, irrespective of the popular vote in their state. And what Trump was saying is, look, there are enough questions about the legitimacy of the election in these states that the state legislatures really ought to step in and just unilaterally overturn the popular vote. And so part of the allegation is that Trump was pressuring state legislatures to engage in that behavior. In a related way, he was pressuring state legislators just to not to take a pause and to say, look, we're not going to do anything until we're able to work out what Trump claimed were some questions about the legitimacy of the election in those states. Now, of course, those questions about the legitimacy of the elections, they didn't pan out. We know that now because he lost so many lawsuits that were challenging the elections in those states. But nevertheless, he pressed forward and argued that the state legislatures ought to put a pause on certifying their votes in their states. He also pressured officials at the Department of Justice to pressure state legislatures to reallocate their electoral votes and to put a pause on the allocation of their electoral votes. And so he went directly to the state legislatures, but he also was working through high level officials at the US Department of Justice. On January 6th, he, of course, delivered a speech and invited his attendees to march on the Capitol and engaged in a number of other kinds of behaviors, tweets, non-actions that led to the insurrection and the Capitol invasion on January 6th. And remember, he pressured Vice President Pence to put a pause on the electoral count and to rule that some states' certified electoral votes were invalid. Now, why did he pressure President Pence, Vice President Pence? Because Vice President Pence was sitting as the president of the Senate in his capacity as the president of the Senate to preside over the electoral vote count on January 6th. And so there were all these actions that Jack Smith alleged in the first indictment. President Trump argued, among other things, that he was absolutely immune as a former president from criminal prosecution for his actions that he took while he was president. Now, this was a breathtaking claim when Trump raised it. The courts have never come anywhere close to saying that a former president is absolutely immune from criminal liability for acts taken while in office. The courts had never come anywhere close to that. And indeed, the lower courts in this case very quickly dismissed those claims and rejected them categorically. The case then went to the Supreme Court, and the Supreme Court reversed. The Supreme Court said that a former president does enjoy some immunity from criminal prosecution for acts while in office. Let me describe how the Supreme Court kind of got there, and then we can, if you have questions or comments about it, we can certainly talk about that. What the Supreme Court said, kind of driving this idea of immunity for a former president, at the core of this immunity is the idea that if a president who is in office is taking official action with a question whether they might be subsequently prosecuted once they leave office, well, we would expect that president then to temper their decisions, right? To be a little bit more cautious in their decision making, knowing that after they leave office, they might be criminally prosecuted for that action. The court said it's that kind of pause that we really don't want our presidents taking when they're making decisions. The presidency was designed by our framers to be an energetic and robust office that can act quickly and decisively. And if the president knows that they may be subject to criminal prosecution when they leave office, that undermines that sort of feature of the presidency that our framers hardwired into the office. Now, what the Supreme Court didn't say is that if a president has some questions about the legality of their decision, maybe it's not a bad idea if they take a pause before they act. The Supreme Court didn't seem concerned about that. What it said was, we just don't want the president pausing before they act. So, based on this idea that a potential future prosecution could chill the actions of a sitting president, what the Supreme Court said was there are kind of three layers of immunity that are built into the Constitution. And just to be clear, by the way, the Constitution says nothing about presidential immunity. It's absolutely silent on this score. And so the Supreme Court really is deriving this immunity from separation of powers principles and its own sort of political theorizing about how a president ought to be treated once they leave office based on how that treatment could affect their decisions while they're in office. So there are three layers of immunity. What the Supreme Court said is at the core of this immunity, when a president engages in what the court called exclusive and preclusive actions, these are actions that the president has by virtue of their Article II powers under the Constitution, and their authorities that the president has that neither Congress nor the courts can encroach upon. These are powers that belong to the president and the president alone, exclusive and preclusive powers. Now, if you want to get a sense of what these powers are, we can think about the commander-in-chief authority, and in particular, the commander-in-chief authority to do what at the core commander-in-chiefs do, and that is direct troops on the battlefield, right? And so that's a exclusive and preclusive power, or the power to grant pardons, an exclusive and preclusive power of the presidency. Some areas of foreign affairs, like recognizing foreign sovereignty, for example, under Article 2, the Supreme Court has told us that that's an exclusive and preclusive presidential power that belongs to the president alone, and that neither Congress nor the Supreme Court can touch or encroach upon. As to those exclusive and preclusive powers, when the president acts pursuant to those powers, the president is absolutely immune from criminal liability, not only while they're in office, but after they leave office as well. A former president is absolutely immune for actions taken within their preclusive and exclusive authority. That's one layer of immunity that the court recognized in the case. Now, if we move out kind of concentric circle. Let's move out a circle and talk about not the president's exclusive and preclusive authority, but other presidential authorities that that the president has under Article 2 of the Constitution. Some of these authorities, for example, they're shared with Congress or with the courts. And here we're thinking about primarily the president's general power to enforce, or we sometimes call execute, the law. A power that the president has, but a power that the president really depends upon Congress to exercise, and can be checked by the courts. As to these powers, what the court said was the president enjoys a presumptive immunity that the government can only overcome if the government can show that the criminal prosecution will not encroach on the president's Article 2 responsibilities, that the prosecution will not have that kind of chilling effect that we talked about earlier. Now, a couple of things are interesting about that level of immunity. One is the court says that it can only be overcome if the government can show that there's no encroachment on the president's Article 2 power. That's a really high bar. That's a very hard thing for the prosecution to show. And moreover, the court said the president is going to enjoy at least this level of immunity, suggesting that the former president, may actually enjoy absolute immunity for all official actions, even those not taken within the president's exclusive and preclusive powers. So we have, with regard to presidential powers that are not exclusive and preclusive, we have the court saying that there's at least this presumptive immunity, maybe absolute immunity. Now, there's one more problem with these first two layers, and we still haven't gotten to the third layer, so hold tight. But with these first two layers, what the court said was there are further restrictions on the prosecution of a former president, even under these immunities. So, one is that the prosecution cannot inquire into the motives of the president. The prosecution is restricted and cannot inquire into the motives of the president. And then, second, that the prosecution can use no evidence that would be protected by these immunities, no evidence that would be protected by these immunities in prosecuting a case against the president. Now, that's going to have a severely sharp and hamstringing effect on any prosecution of any former president. Third level of immunity. Let's just finish out the story. What the court said was there's a third level of immunity that actually is no immunity at all. And what the court said was a president enjoys no immunity for unofficial acts. But again, remember that if a prosecutor wants to prosecute a former president for unofficial acts for which they enjoy no immunity, the prosecutor cannot inquire into the president's motives, and the prosecution cannot use evidence that would be subject to one of those earlier immunities that we discussed. Now, what all this meant for the January 6th case, the Jack Smith case that was in the DC courts and that went to the Supreme Court, is that Jack Smith went back to the drawing board. He issued a superseding indictment that tried to take out all the information from the original indictment that would raise one of these immunities. And so, for example, he took out references to former President Trump's discussions with Department of Justice officials on the theory that discussions with Department of Justice officials are part of a president's exclusive and preclusive powers. And so, whatever the subject of those discussions, however illegal they might have been, they're protected by that absolute privilege of exclusive and preclusive power on the part of the president. And so Jack Smith took out reference to all of those discussions, for example, and then went ahead and issued the superseding indictment. We've had a court hearing recently about how we're going to sort all this out and what the parties are going to do. This is going to be worked out in the lower courts, but one thing we know for sure is that it won't be worked out before the 2024 election. And what that means is that we as voters are going to be going to the polls without knowing whether a major party candidate and somebody who's polling, at nearly 50%, nearly even these days, that somebody in that position, whether they're guilty of engaging in an insurrection against the United States, we just won't have that information because of the delays in this case. But more, the January 6th case was not the only case that was going on against President Trump, former President Trump. We know, for example, that he was subject to the hush money case in the New York State courts with Judge Merchan. Well, he was convicted in that case, but as soon as the Supreme Court immunity came down, Trump moved to dismiss his conviction in the New York State case on the theory that the evidence that the prosecutors used in the New York case were subject to immunities under the Supreme Court's ruling this summer. And just to give you a sense of that, for example, some of the evidence that the prosecutors used in the New York case were things like Hope Hicks's testimony, right? A testimony about conversations that she had with former President Trump in the Oval Office. What the Trump team is arguing is that conversations like that are part of the president's exclusive and preclusive power to be able to talk to high-level advisors and officials in the Oval Office in confidence with the assurance that those conversations will not be later revealed. And what the Trump team is arguing is that by using evidence like that to convict him in the hush money case, the prosecutor was drawing on evidence that would have been prohibited under the Supreme Court's ruling on immunity this summer, and so moved to dismiss the entire case. They also moved to push back the sentencing in that case, which, if you'll remember, was scheduled for just next week. And Judge Merchan, out of an abundance of caution and in order to avoid any appearance of political decision making, went ahead and deferred decision making on immunity and on sentencing until after the election, which means that now the Supreme Court case has affected not only the information that we have about Trump's guilt or innocence with regard to insurrection in DC, but also with regard to his immunity in the New York case. And there's yet a third effect. You'll remember that Jack Smith had filed against Trump a separate case entirely in Florida, where Smith was arguing that Trump had illegally retained government documents, including highly classified government documents at Mar-a-Lago. That case was before Judge Cannon, who had been slow walking this case from the beginning and allowing motions to back up. This case was just moving very, very slowly. Well, Judge Cannon ended up flatly dismissing the case in recent weeks, and she did it on the ground that Jack Smith was invalidly appointed as special counsel. This was extraordinary. Every court to have looked at this question, including the Supreme Court, had ruled that the Department of Justice can appoint a special counsel just as the Department of Justice appointed Jack Smith. This is well decided in our system. And so for her to rule this way, really turned some heads. You might wonder, well, on what ground was she ruling this way? Well, Judge Cannon ruled that way based on Justice Thomas's concurrence in the immunity case that came down this summer. Justice Thomas went out on his own in the immunity case, and he wrote a separate concurrence just for himself, arguing that Jack Smith was invalidly appointed as special counsel. He didn't get any other votes on the Supreme Court. It was an extraordinary opinion because nobody had briefed the issue at the Supreme Court. Nobody had argued the issue at the Supreme Court, and the Supreme Court didn't agree to review that question. Yet, nevertheless, Justice Thomas went out on his own and argued in a concurrence that Jack Smith was invalidly appointed. Well, Judge Cannon picked up on that idea and issued a 90-plus page opinion within a couple of weeks of Justice Thomas's concurrence that riffed on this idea that Jack Smith was invalidly appointed, and on that ground dismissed the entire case. So now we have yet a third case where we won't know if a major party candidate for the presidency is guilty or not of a major crime because of the Supreme Court and a lower court judge slow walking this decision. So what we've seen is the Supreme Court not only aggrandizing the power of the presidency, in some ways jaw-droppingly aggrandizing the power of the presidency in the immunity case, and we can talk a little bit more about that. I can give you some examples if you're interested. But also depriving us, we the people, of critical information going into the 2024 election. And so, whether you're for Trump or against Trump, wouldn't it be good to know whether he would be guilty in front of a jury of his peers or not of these significant crimes before you go to the polls? And we just won't have that information. So I'm going to pause here again and just see if there are any questions.
I'm gonna read these questions from the bottom up here. What do you think about Prosecutor Smith's use of testimony from VP Pence as officer of US Senate in the insurrection case against Trump? And to what extent do you think this bypasses presidential immunity?
It's a terrific question. A really, really good question. One of the things we don't know coming out of the immunity ruling, and we won't know probably for some time, if ever, is whether Trump's communications with Vice President Pence in his capacity as president of the Senate, whether that's part of the president's exclusive and preclusive powers. I don't have an answer for you, but I can lay out the arguments, and you can use your own judgment about what you find more persuasive. So on the one hand, on the one hand, the president themselves does not have any role in the electoral count under the Constitution, no role whatsoever. The president has no role in the election whatsoever, except to the extent that somebody is actually violating election laws. And moreover, the vice president is sitting in their capacity as president of the Senate. In other words, in their capacity as a congressional officer, not an executive officer. Now, when you put those two ideas together, what some say is, look, the idea that Trump was communicating with Pence has nothing to do with Trump's exclusive and preclusive power, because Trump doesn't have anything to do with the electoral count, and Pence is sitting in his capacity not as vice president, but rather as president of the Senate. So, on the one hand, there's a sound argument that says this should not be subject to immunity, and that Jack Smith should be able to, for example, call Pence and subpoena him to testify in the case. And that Trump would enjoy no immunity over those communications. Now, on the other hand, there's an argument that Trump does have some authority to intervene when there are election illegalities. This is the argument that the Trump team has consistently promoted, that the president, of course, has a role in protecting our nation's election laws. And when there's election fraud or other election irregularities, that the president can and must get involved in it. And communicating with Vice President Pence, whether as president of the Senate or as vice president, is not only part of the kind of confidential communications that ought to be exempt from subpoenas in court hearings, but moreover, really is part of that exclusive and preclusive power of the president. Now, again, these are Trump team arguments. I will confess that I don't find them very persuasive, but those are the arguments, and we'll see this play out first in the lower courts, but probably up to the Supreme Court, unless, and here's a big unless Trump is reelected to office in 2024. If he's reelected to office in November, what we'll expect Trump to do is order the entire prosecution shut down, and or grant himself a pardon and dismiss the entire thing, in which case we'll never find out whether his communications with Pence would be subject to a kind of immunity or not.
Interesting. Okay.
Yeah.
This is a more general question. Wondering if the Electoral College vote is not settled by January 20th. Does the sitting president remain in office until it does get resolved?
Well,
uh-oh, did we stump you?
I think you stumped me. So I don't have a great answer to that question. Thankfully, we haven't had to answer it. Um, when we've had disputed elections in terms of the electoral count, they've resolved themselves either through a congressional vote, which is how the Constitution provides for this, or through some other mechanism. But we haven't had a situation where there's a question about a state certifying its electoral votes before the date for the inauguration for the new president. As I'm saying this, I'm reflecting back on the 2000 election, and you'll remember that the Supreme Court stepped in and moved very quickly to shut down the recount in Florida on the theory that we needed to have things settled before the electoral count on January 6th. And I suspect that through one mechanism or another, the court system or some other political actors would intervene to assure that that doesn't happen.
So that's a good segue, I think, into this next question, if I'm understanding it correctly. Does Congress have the constitutional power to make the allocation of electors proportional to the vote of the state rather than winner take all? The count would probably reflect the popular vote more closely, and which he's referencing as Article 1, Section 4 gives Congress control of federal elections.
Yeah. So would Congress have the power to do that? Again, I don't have an answer to that question. We don't know. There are arguments both ways. Congress does have some authority over federal elections operated in the states if it wishes to exercise that authority under the Constitution, as the questioner mentioned. But the extent of that authority, it's not clear that it would reach to a question as significant as whether a state is going to allocate its electoral votes by winner take all or in a proportional kind of way. An argument against that kind of authority would be that that could be a significant encroachment on state sovereignty and states' authorities to determine how they're going to allocate their own electoral votes. An argument in favor of it would be that Congress, by setting that kind of standard, could set a nationwide uniform standard in terms of the way that states are going to allocate their electoral votes. Either way, I don't see Congress ever doing that, at least not as it's currently comprised. And again, I kind of hate to default to this as an answer, but we don't really know in our constitutional system the extent of Congress's authority to regulate federal elections in the states to that extent. It is clear that that Congress does have some authority to regulate federal elections in the states, but whether it would go that far, I think, is a different question.
Thank you. And one last question. Because this immunity ruling is so bizarre, will every time immunity is invoked by the president, will the Supreme Court have to decide whether the president is immune or not? In other words, what part of that three circles does the president's action sit in? Will the Supreme Court need to decide that?
Well, okay, so I'm going to answer with regard to the Trump case. The Trump case will invariably go back to the Supreme Court on that very question. What do we mean by exclusive and preclusive power? Is the second layer of immunity, is that a presumptive immunity, or is it an absolute immunity? How does it operate? The excellent question about Vice President Pence will undoubtedly go back before the Supreme Court. We will see further litigation and further decisions at the Supreme Court on these questions. That is, unless Trump is elected in November and shuts down the prosecution. I don't know when this will happen. It could happen, I suppose, as soon as next summer. although that seems very quick to me. But these questions will go back to the Supreme Court. As to any other former president, we've been around for quite a while, and we haven't had to deal with this question of a former president's immunity from criminal prosecution until 2024 with Trump. Let's hope that we don't have to deal with it again. And so, will the Supreme Court have to answer these questions with regard to some other president? Good grief, I hope not. We haven't for a long time. We've had to only once in our country's history. Let's hope it doesn't happen again.
I hear you. Okay, that is all the questions right now, so I'll let you go ahead and move on.
Okay, terrific. Thank you. And I'd be more than happy to engage with anybody on email if you have follow-ups to some of these really, really good, probing, fantastic questions. Is part of the reason I love working with league chapters so much. Getting this kind of dialogue and these kinds of questions, even when I can't answer them, it's fantastic. So I'm mindful of time. I do want to mention the couple of other things that I had sort of outlined at the top, and that is the Supreme Court's uh, really really evisceration of the administrative state, and then what it's doing with fundamental rights. And so I'm going to talk about those at a kind of high level of abstraction. And if you want to go into the details, we can do that. Or if you'd prefer to follow up on email, I'd be happy to do that as well. Let's start with the administrative state. We've seen now for a couple of decades going back, the Supreme Court moving in the direction of slowly chipping away at the power of the administrative state in a lot of different ways. I think about this as kind of death by a thousand cuts. And the opponents of the administrative state are strategically lodging this litigation and bringing these cases before the Supreme Court, a Supreme Court that it now has found friendly and receptive to these kinds of claims, to slowly chip away at the administrative state. And by the administrative state, I mean all the administrative agencies, this sort of alphabet soup of administrative agencies that sit within the executive branch. Now, from a separation of powers standpoint, it's really important to understand that these administrative agencies, they're not specified in the Constitution. Congress has the authority to create them, invest them with authority, and fund them in the first place. And so the Environmental Protection Agency didn't just fall out of the sky. Congress created it, it vested it with authority to enforce our environmental laws, and then it gave it money to do that enforcement. The Consumer Financial Protection Bureau, the exact same thing. Congress created that agency, it vested it with authority, and then provided a funding mechanism for it so that it could do its work. And so Congress has a serious hand in the administrative state, even if ultimately the administrative state answers to the president in terms of their day-to-day enforcement of the law. And so in that sense, the administrative state has a kind of creator in Congress, but a boss in the president. What we've seen is the Supreme Court chipping away at the administrative state in terms of chipping away at the structure of different agencies within the administrative state. And so, for example, when Congress has tried to create independence within the administrative state, political independence, so that organizations like the Consumer Financial Protection Bureau can protect consumer financial protection laws without being subject to the day-to-day political whims of the president. When Congress has tried to design that kind of political independence, the Supreme Court has slapped it down and said, no, you can't do that. When Congress has tried to design political independence with a board, the Public Company Accounting Oversight Board, that sat within the Securities and Exchange Commission, the Supreme Court has said, no, you can't create that kind of independence either. And so the Supreme Court has been moving in the direction of preventing Congress from creating agencies within the executive branch that enjoy a level, not complete independence, I want to be clear about this, but enjoy political independence from the presidency. And we've seen a kind of trend line here that I think many are concerned, and I share this concern, that the court is on the cusp of overturning any kind of political independence within the administrative state. And what that would mean then is that formerly independent boards like the Securities and Exchange Commission or like the Federal Reserve, for example, that the structure of those would be changed fundamentally so that they answer directly to the president, and the president could swap out officers on those boards at their will and make decisions that are rotely political and politicize those agencies that we have come to see and come to accept as independent with our system. So that's one way that the
Steve, can I
Supreme
interrupt
Court.
with a question of my own for a moment?
Oh yeah,
Because
yeah, yeah.
I'm
Please,
not
of
sure
course.
that
Mhm.
I'm clear on how the structure works. Could Congress create an agency that does not sit within the executive branch? Or is
Sure.
that the way the Constitution is set up? So help me understand that dynamic a little bit.
Yeah, for sure it could. So, for example, Congress has set up agencies within the legislative branch, agencies within Congress. Now, they're not enforcement agencies because Congress doesn't have the power to enforce the law. Only the executive branch has that power. But they are agencies that help Congress with its lawmaking function. And so Congress can create other agencies outside of the executive branch, but it cannot create enforcement agencies outside of the executive branch because the executive branch is in charge of enforcement in our system, not Congress or the courts. And so ultimately, any enforcement agency does have to answer to the president and in that way sit within the executive branch.
Makes sense. Thank you.
Um, and so, sort of chipping away at the independence of these agencies is one way that the court has chipped away at the power of the administrative state, but it's done it in other ways too. So, for example, the court in recent terms has kind of created, apparently out of whole cloth, this idea of a major questions doctrine that says if Congress empowers an agency to enforce a law, that um, that the agency, if in enforcing the law, makes a significant political or economic decision, that it needs to rely on express power from Congress to make that decision. Now, that all sounds kind of wonky when I say it like that, but when the rubber hits the road, it actually is really quite significant. We've come to accept in our system that Congress legislates at a very high level of abstraction. It tells, for example, the EPA, hey, go out and make the air clean. It doesn't tell the EPA at what level of airborne particulates or certain airborne particulates the EPA needs to determine that the air is dirty. Why? Well, because Congress doesn't have that institutional expertise. It relies on the experts at the EPA. And moreover, that determination may change from decade to decade, depending on how air quality changes. And Congress can't keep up with those changes, but the experts at the EPA can. So, what the Supreme Court has done is significantly hamstrung agencies to use their agency expertise and their kind of flexibility and pliability and enforcement when they're given general enforcement authority from Congress, as they almost always are. Now, what this means is that it really is gonna affect agencies like the EPA or like the Consumer Financial Protection Bureau or like any of the enforcement agencies who rely on authority from Congress and are interpreting that authority in ways that the court thinks raises significant political or economic effects. We've seen that now in operation in a couple of different cases, and it really is sharply limiting the power of the administrative state. Now, all of these strategies to slowly chip away at the administrative state by opponents of the administrative state and by those friendly to those claims on the Supreme Court, these have invited sort of more aggressive claims against the administrative state. And we saw a couple of those this term. So, for example, we saw a challenge to the Consumer Financial Protection Bureau based on its funding mechanism. The CFPB gets its funding from the Federal Reserve, which in turn gets its funding from bank assessments, private bank assessments, outside of the, and here I'll use air quotes, the ordinary appropriations process in Congress. And the reason I use air quotes is because there really is no ordinary appropriations process in Congress. Congress can appropriate in a wide variety of different ways, but they typically grant agencies a 1-year appropriation that comes from the federal treasury. So the opponents to the CFPB have seen this kind of trend line on the Supreme Court and said, well, let's raise yet a different kind of challenge against the CFPB. Let's challenge their funding mechanism. And the Supreme Court actually rejected that challenge this term, thank goodness. There were some challenges to the structure of the Securities and Exchange Commission that the Supreme Court rejected as well, although the Supreme Court did rule that the SEC could not issue civil penalties for SEC violations through the administrative process. If the SEC wants to administer civil penalties, it has to do it before a jury in court, which is going to be a significant restraint on federal agencies' enforcement. But the real big case this term was a case called Loper-Bright involving a doctrine we call the Chevron doctrine. And here we really do get into the weeds of administrative law and separation of powers. What the Chevron doctrine said is that when a federal law that authorizes an agency to act, when that federal law is vague, it's susceptible of more than one interpretation, that the courts, when they review an agency action, they're going to defer to the agency's interpretation so long as the interpretation is reasonable. Now, that's a low bar, and what it means is that agency interpretations of vague federal laws will usually pass muster in the courts. Think again about Congress enacting the Clean Air Act at a very high level of generality, and then the EPA regulating particular airborne particulates at particular levels. Is the EPA interpreting the federal law validly or not? Well, the Chevron doctrine would say you defer to the agency in making that decision. The Chevron doctrine has long been a target for those who oppose a robust administrative state, and they've been arguing in different cases that the courts ought to overturn it. And this term, the Supreme Court overturned it in the Loper-Bright decision. What the Supreme Court said was, in interpreting vague federal laws, the courts should not defer to agencies' interpretations. The courts should interpret those laws themselves without any deference to the agency interpretation. So courts should take it upon themselves to interpret a Clean Air Act, for example, and whether the EPA is enforcing the Clean Air Act in a way that's consistent with the language of the Clean Air Act, with no deference whatsoever to the agency's interpretation. Now, again, this all sounds kind of wonky, and you might think, well, who cares? The thing is, this is really going to restrict agencies, federal agencies that regulate our environment, that regulate health and safety in the workplace, that regulate food and drugs, all those things that we rely on, but we don't even really think about every day. It's going to significantly hamstring their ability to interpret federal law that authorizes them to regulate. And this term, the overturning the Chevron doctrine, we don't really know the kinds of effects this is going to have yet. We're seeing a lot of different challenges and cases in lower courts, but it will have sweeping effects. There was yet one more administrative decision that could have significant effects moving forward. It's a case called Corner Post. Corner Post involved a challenge to a regulatory scheme by the Federal Reserve that regulated fees that merchants could charge on debit cards. This has been a regulation that has been on the books for a long time. Corner Post was an organization, a corporation that only recently incorporated. And Corner Post brought what we call a facial challenge to the regulation, arguing that the regulation was completely invalid, not only with regard to the plaintiff in the case, but with regard to everybody, that the regulation was just completely invalid. Now, the problem with that claim is that it came up well after the statute of limitations under federal law to lodge that kind of claim in the federal courts. The case went to the Supreme Court, and the Supreme Court said the statute of limitations doesn't start tolling until a corporation is formed and is affected by a regulation. What that means is a corporation who wants to challenge a regulation that's long been on the books can suddenly incorporate today in 2024 and go ahead and challenge that regulation on its face as facially invalid, not only as applied to the organization or corporation, but with regard to everybody. Even though they've long passed the statute of limitations, and even though the um, the regulation has long been on the books. Now, this overlaps with yet a different decision that we saw this term in the mifepristone case. And so those of you that were following know that mifepristone is one of two drugs that's commonly prescribed to induce an abortion, and that the FDA's approval of mifepristone has been under attack. Well, the thing is, mifepristone has been approved since 2000. It's long been on the books. It's been determined a perfectly safe drug for a long, long time. And challengers, the Supreme Court ruled this term, lacked standing to challenge the FDA's approval of it. Well, when you put the mifepristone case together with the Cornerstone case, what Cornerstone says is that a new corporation could incorporate today in 2024 and allege that mifepristone is harming it in some way, that the Supreme Court now has created a kind of template or outline for a corporation to make that kind of claim, that they could incorporate today in 2024 and challenge the FDA's approval of mifepristone, not only as to the corporation, but with regard to everybody, even though the FDA has had this approval on the books for several decades. So the corner post case, taken together with the mifepristone case, is yet another way that we're seeing challenges to the administrative state. Um, I know we're running short, but I'm just going to mention what's going on with fundamental rights. We all saw the Dobbs opinion overturning Roe versus Wade, and we saw the Bruin opinion upholding gun rights in a new and different way using a history and tradition test. And if we were paying attention, we saw the other term that the court signaled that it would apply a history and tradition test to religion clause claims as well. It looks like the court is moving in this direction of applying history and tradition to fundamental rights across the board. Well, the problem with this is that the court itself can't seem to agree on what history and tradition means, let alone the fact that judges make really, really lousy historians and can't do this very well at all. The justices who have gone with a history and tradition approach, the political conservatives on the court, they can't agree among themselves what history and tradition we're going to look at and how we're going to interpret it. And this is deeply troubling. It came up in a case called Rahimi this term involving Second Amendment rights with regard to an individual who was under a domestic violence restraining order, and really pressed the court on its history and tradition approach. The court escaped what could have been a deeply troubling and uncomfortable ruling in the Rahimi case, but it did so really by contorting itself and contorting this idea of history and and tradition. And so, what's up next with history and tradition and our fundamental rights? We have no idea. The court really seems to be spitballing with this test, and that's something that, in my view, we ought to all be very deeply concerned about. I'm going to stop and see if there are questions or comments.
There is one question. It does sound, by the way, like we are potentially in for a bit of legislative whiplash over maybe the next several years here, and so we'll definitely need to be following up as things continue to evolve. But the question here is in a hypothetical situation where Trump is elected and he wants Biden to be prosecuted for something he perceives that he did illegally,
Mhm.
would not the SCOTUS decision also offer immunity to President Biden in this example?
In theory, it would. Yes, in theory, it would. And I say in theory because sometimes the courts don't always apply these separation of powers principles on an equal basis the way that we would like and expect them to. But what I said at the beginning holds with regard to the immunity decision. Separation of powers decisions don't work one way, or at least they shouldn't work one way in our democracy. They work both ways. And so an immunity for Trump will mean an immunity for all future presidents, for all actions, whatever they are, whether we like them personally or politically or not. And so, again, what I tell my students is a good measure of your separation of powers kind of instinct is whether you would accept a separation of powers principle, both for your favored politician, but also your disfavored politician. And if you wouldn't accept it both ways, maybe it's not a great separation of powers principle. And that's kind of where I come down on the immunity ruling.
Thank you, Steve. I don't have any other questions, and as I'm sitting here trying desperately to figure out how to re-show myself on the screen, I'll ask those of you to forgive me for being the little tiny head above the screen here, but thank you so much. Great insights, lots to cover tonight, and good guess that you'll be back with us in the next several months here to maybe take a deeper dive into a topic or two. So again, thanks a million, and really appreciate your support this evening, helping us out with some education on this.
Well, Kathy and everybody, it's been a true honor. Again, I just so enjoy working with the league. It's such a wonderful opportunity to engage in these important issues. So thank you. Thank you. I appreciate it.